Hi, everybody. This is State Senator Scott Surovell. I'm here with my colleague, Delegate Marcus Simon, and we're here to give you the 2021 General Assembly session update about what happened this session. It was actually a big session, not quite as big as the last one, but still pretty big. We have a lot to talk about. Really quick, again, my name is Scott Surovell. I'm a state senator for the 36th Senate District. I represent Eastern Fairfax County, Kingstown area, Mount Vernon, Lorton, Mason Neck, pieces of the Mount Vernon and Lee magisterial districts. I also serve as the vice chairman of the Senate Democratic Caucus. And I'm a former Fairfax County Democratic Committee chairman. I chaired the Fairfax County Democratic Committee from 2007 till 2009-ish. And I chaired the Mount Vernon District Democratic Committee for 4 years before that, starting with the Kerry Edwards election through 2007. So that's a little bit about me. We'll kick into the program a little bit, but hopefully let's let Marcus, Marcus, why don't you say a few words about who you are, where you represent, et cetera.
Sure. So thank you, Scott. I am Delegate Marcus Simon. I represent the 53rd House District, which is Falls Church City down the highway into Merrifield, all the way up to about the Vienna Metro stations where we stop. And then we go north from Route 50 up to Pymmet Hills. So it's a fairly compact, contiguous district. It is mostly in Falls Church and Fairfax County. I am the secretary of the House Democratic Caucus, also the House Democratic Parliamentarian, which gives me an active role on the floor of the House. I chair the Privileges and Elections Committee in the House as well. I serve on the FOIA Council, the Code Commission, Housing Commission. Those are the highlights. And I'm a member of the new Redistricting Commission, which I spoke to some of you guys at FCDC about last week. I was admonished at our official commission meeting today that I wasn't supposed to do that, but I got one in for FCDC. I figured it's better to ask forgiveness than permission on some of these things. So I've been a member of the General Assembly since 2014. Scott and I served there together for about 4 years before you left. We both, when I came in,
I'm still there. I just moved down the hall.
Well, when I got to the House, I should say though, we were I think our low point of 32 with my election after some special elections, and so it's been very exciting to build back up into the majority, and now we've got the trifecta. And as Scott said, it felt like we did a ton in 2020, and then in the special session. And I was thinking as we were putting together tonight's presentation that there wasn't a whole lot left that we did this session, but there was a lot that we still did this session. And so I think we can go ahead and jump into that if you're ready, Scott.
Yeah, it's going to take a while. We got to blast through this stuff, and we're probably going to get a lot of questions about stuff we didn't even mention. So,
all right. So I'm going to go ahead and put up some slides that we put together. Like I said, we'll blast through as much of it as we can to try and get to some questions. So that's us. Scott, you just heard from us. We want to start, Scott, with some courts and criminal justice reform stuff that we did, starting with, I guess, marijuana legalization. Oh, just remind everybody though, this law does not have an emergency clause on it. All right. It's not yet legal. Wait until July 1st. Go ahead, Scott.
Yeah. So we passed a little bill about marijuana. This is the biggest bill some members had ever seen. It was 280 pages, 13,000 lines long. I actually printed it out and measured it. It's about 2.5 inches thick if you print it out double-sided. It was a lot of it was a lot of work this session. I probably spent 12 hours in committee in session vetting this bill. After session was over, I probably spent another 8 to 12 hours talking with people in different meetings about getting the bill refined. We finally approved the last set of amendments to it last week at the veto session. But just so we're clear about what the bill does, it legalizes the adult possession of small amounts under 1 ounce, and it also legalizes growing up to 4 marijuana plants at home per household. That's what it does. It does not legalize the sale of marijuana in any way. It does not allow you to smoke it in public. As I said on the floor, this does not allow you to have like a ganja fest at Jiffy Lube Pavilion. This does not allow you to possess it in a school bus or on school property. It does not allow you to have an open container of it in your car. It's possession of a small amount by adults. Juvenile possession is still illegal. It's also illegal to give marijuana to children or people under 21, adults under 21. And we also passed some ceiling provisions, which didn't get a lot of attention. The bill says that starting July 1 of 2025, if you have any mention of marijuana possession on your criminal history, it is automatically sealed. If you have a misdemeanor marijuana possession, we call that PWID, possession with intent to distribute. If you have a misdemeanor marijuana possession charge or conviction, that will also automatically be sealed. And if you have a felony distribution conviction or a misdemeanor paraphernalia conviction, you can petition a court to have that sealed. Again, all starting July 1 of 2025. We have to do a bunch of computer work to get the computer systems in a place to where it's not going to cost us a fortune to process all that. But that's what that bill does. It also sets up some boards and commissions and new cannabis control authority, which is going to start now. But we did not pass any binding legislation about recreational sale, recreational growing, recreational manufacturing, taxes, distribution of revenues, and all that. All that is stuff we still have to work out, which is the meat of the bill, which is very complicated. I don't know, Marcus, anything you want to say about that?
I just want to add, there's a lot left to do on marijuana. And I think that, we heard from folks that they didn't want to wait for us to figure out all those details before we got to legalization and beyond just decriminalization. There's this big social equity aspect of this that's important to a lot of us in the House in particular, and making sure that the licenses that go out are targeted towards communities that have been impacted by over-policing of drugs and marijuana and so forth. So there's still a lot of debate about what that's supposed to look like. We do have some models in other parts of the country. I think Massachusetts has a good social equity model. I think New York just did something that involves that as well. So I look forward to continuing to work on that particular aspect of it. And there's a lot of it that's, again, going to take some time. It was a lot to try and tackle. It was sort of surprising to think that we could try and get all that done in the space of a short legislative. I mean, it wasn't short. Well, it was short for a variety of reasons, but this is our short session compared to our long session already. And to have this sort of dropped on us was a lot to take on. But I think we got made some good progress, have a good framework to build on. And I was pleased the governor sent down the amendment to get us the small amounts legalized going forward. Yeah, another small bill that we worked on. We abolished the death penalty in Virginia, Scott. That was your bill and Mike Mullen's bill in the House. But before I let you talk about that was one that I think probably you and I worked on together. I remember the 2016 reconvened session.
Yep.
We fought the Democratic governor and the Democratic attorney general at the time. It seemed like we were the only guys, those Democrats in the legislature, that small number of us. You were in the Senate by then. We're trying. Senator McAuliffe said, if you guys don't pass this bill, we've effectively killed the death penalty. He said, perfect, right? That was the plan. I thought it would be a long time before we could get here. I was pleased to see that the Commonwealth's moved in that direction. But go ahead. Why don't you talk a little bit about it? It's your bill.
Yeah, public opinion has really changed massively on capital punishment since I started serving. When I first got elected in 2009, I remember in one of my first debates when I was running for the House of Delegates, I was worried I was going to get asked a question about it because I was afraid I was going to lose a bunch of votes if when I told everybody what my position was. But I never got a question about it the entire campaign. But and if I had put in, if we had a capital punishment repeal on the floor of the House of Delegates in 2010, I think we might have got 10 votes, maybe 15. And it's really amazing to me how much things have changed. But what the bill did was it changed the definition of capital murder into aggravated murder, and it eliminated the death penalty for any crime, and it converted the two men who were currently on death row into life in prison without the possibility of parole. That's effectively what the bill did. It also eliminated we also eliminated the Capital Defender Service, which costs us about $3.4 million a year for staffing, and it's really amazing because Virginia, our government in Virginia has executed more human beings than any other government in the Western Hemisphere since the English got here. 1,300, almost 1,400 people since 1608. And we have the second highest number of executions since Furman v. Georgia in 1976. Most people just didn't think Virginia would ever like lose its interest or its interest in executing people. But I think the lack of death sentences in Virginia over the last 10 years has made a big difference to people. We haven't had a single death sentence rendered in a Virginia court for 10 years now. There's only 2 people left on death row. You know, Virginia is increasingly an outlier in the world on this. I mean, you know, we stand with countries like Egypt, Saudi Arabia, China, North Korea. We were up there with ISIS for a little while when they were doing their thing. I mean, there's no Western countries that execute people anymore. I think the exonerations have made a big difference. The 180 people who've been exonerated by DNA has just caused a lot of people to question, how is it possible to justify executing 9 guilty people for when an innocent person could die? And the data shows that about 1 out of 10 people are innocent. So I just don't think a lot of people can morally justify that anymore. And I'm really glad we were able to get this done. I didn't think it was going to come this fast. I don't think anybody did, but we got it done. And the weird thing about this bill is that a lot of people feel connected to it, even though it hardly affects anybody. And that really was odd to me. I've done a lot of bills that have affected a lot of people. Like last year, we passed driver's licenses for undocumented people, 300,000 undocumented immigrants. We got Marcus and I helped get Medicaid for 400,000 or 500,000 Virginians. This bill affects like 2 people and maybe like 1 case a year or something, but everybody feels connected to this policy, and it really makes everybody feel better about their state. And so I'm really excited we got it done.
Yeah, you know, one other thing that I think kind of drove the momentum on this for this year, frankly, was Donald Trump. I mean, I think his killing spree that he wanted to go on and really, you know, ramp up the pace of executions. I think people found that so distasteful and really put a fine kind of point on what an awful practice that was. So, yeah, I think that again, in Virginia, I think that helped sort of get us to where we needed to be and help some Democratic legislators you know, feel like it was politically the right thing to do, as well as the morally and ethical thing to do. So, and I was, you know, we had some strong in the House side there. There were, even the Senate too, very vigorous debate. And I was worried we might lose some squeamish folks, but everybody held strong. So,
and I was worried too. We had a couple of people who were on the fence, and we were luckily able to hold them down. Governor Northam's endorsement made a big deal, made a big difference.
All right, I'm going to go ahead and throw the slides back up again. I'll take it up and down a little more often, so we aren't just disembodied voices to the folks on Facebook Live. Mental health in criminal proceedings. This was another one of your bills, sealing of criminal records. You talked a little bit about this with marijuana. This is what a lot of us think of this as expungement, but you actually, in particular, Scott, have been sort of concerned about a full-scale expungement and been sort of insistent that we try and be careful and deliberate about getting this right. So why don't you tell us why we're calling this sealing as opposed to expungement?
Yeah, well, so Virginia is one of only 8 states in America where you can't seal a misdemeanor conviction after, and only one of 14 states in America where you can't seal a felony conviction at some point in time later in your life after you've shown a period of good behavior. So this bill, we took a mix of the House and Senate approach. The House really was focused on automatic expungement, and the Senate, we were focused on a petition-based system, and we ended up doing a hybrid of both. So under the bill we passed, there's about 8 crimes that will be automatically expunged if you can show a period of good behavior of 7 years. And under the other part of the bill, for basically every other crime, class 5 misdemeanor down, excluding DUI and domestic violence, you'll be able to petition to have a charge sealed. And the difference between expungement and sealing is that if something's expunged, that means it's just gone. It's gone forever, disappeared, gone. It's basically impossible to ever find again. But with convictions, they have to be sealed instead of being expunged, because there's some types of professions where the federal government requires employers to look into them and find out about them. For example, if you have a security clearance, if you work at a bank. And there's other types of jobs that deal with sensitive positions where people are dealing with children or other people in vulnerable situations, that it's important that employers be able to have access. And so basically what the bill says is that for certain jobs, there'll be a limited subset of jobs where you can file a special form and take a peek, but everybody else, if a charge is sealed, you can't see it anymore. And that brings us into line with probably 40 other states in America, which is where we need to be. And now we've got that foundation, we can build on it going forward. We also created some civil liability for these background screening companies that put out reports on people, because if they continue to put out these background reports that show charges after they've been sealed, it's completely pointless. And that was another bone of contention we were able to work out. And unfortunately, because again, the computers, we can't make any of this effective until July 1 of 2025. So
Yeah, well, right. Otherwise, the fiscal impact is always enormous.
it's like 70 or 80 million a year.
Yeah, they tell us it is, right? To upgrade all the, like, we can change the computers now, but it's going to cost you. Then tell me, remind me, you said a little bit about this, but where did we land on automatic versus petitioning for? I know the Senate wanted us to have to petition for all these, but there's certain crimes that we made where you don't have to go hire a lawyer and go back into court to get it sealed. It's going to happen automatically.
Automatic expungement is for things like marijuana possession, which of course we took care of later after we passed the marijuana possession bill after the fact, but it was marijuana possession, it's petty larceny, trespassing. It also, I think, applies to traffic offenses after 10 years. And there's
pretty much anything beyond that sort of list. You can get anything sealed under a motion, right? So if you go back to court and you can move for it, we now have a
class 5, class 6 felony, all misdemeanors, except you cannot get it for DUI or domestic assault.
Gotcha. Well, that's because domestic assault, some of these are crimes that pile up. So second degree, second and third offenses of some of these crimes have ramped up consequences. So if you expunge them, you never get that. You never realize that that's a second or third.
DUI has a bunch of federal rules around that we couldn't get into. So that's what happened with DUI.
Gotcha. All right, let me pull the slides back up again.
You do mental health.
All right, I'll try to do mental health. So we had a bill. It's interesting. This one was tricky to get right. These bills that Delegate Bourne and Senator McClellan put in came out differently than they started. But these were really important to people, particularly in the disability community. But it started out fairly simple. Just want to be able to consider the mental health status or the ability or inability to sort of form mens rea, right? Or the legal standard you need to form intent to commit a crime. And the concern was that you essentially were making going to a really easy, low standard for not guilty by reason of insanity. You have something that was sort of the equivalent of a not guilty by reason of insanity, but without any of the other protections for the community that are built in when someone's found not guilty by reason of insanity. So this bill got narrowed a little bit, but it does permit admission of evidence by the defendant concerning their mental condition at the time of an offense. And it does allow experts to come in and testify if it's determined it's relevant. It isn't considering an ultimate issue of fact and tends to show the defendant did or did not have the intent required for the offense charged. We also put in some stuff here about detention orders and creating an opportunity. So if somebody doesn't have the mens rea necessary to be found guilty of the crime, but is still a danger to the community, they don't get turned loose automatically. And so we've got some enhanced language in there to make it easier to get these emergency protective orders and emergency detention to get them into treatment, mental health treatment, so they're again not just turned loose without any kind of services or any kind of protection for the community at large. Big deal for folks on the autism spectrum in particular. A lot of times people with autism spectrum disorders would present to somebody who wasn't properly trained in recognizing it as being defiant. And we've seen what happens when police find somebody defiant. They kind of tend to ramp up things as opposed to de-escalating things. And so you get folks charged with assault.
Marcus, let me tell you, this bill, though, this bill is a big bill. And it's a really big bill because it has the potential to impact every single criminal case that's charged. And just to give you an example, say somebody's got serious depression, they get picked up shoplifting, they can put in evidence on the case in chief to show they had this depression issues, they had difficulties with self-control, and that can be taken into account to figure out whether they intentionally shoplifted something. Or for example, assault and battery, same deal. Your Honor, I was going through some really intense depression. I was, it made me, I had difficulty controlling impulses, or they show some sort of, and they can put that on the case in chief instead of having to go through, get convicted, and then only put it on in mitigation of sentence. This is basically what has been the model penal code since like the 1970s. Virginia's has been way behind everybody. So it's about time we got up to speed.
Yeah, well, and it's, a over the objection of VACA, but I think that we've got some good reform-minded prosecutors that are also helping
Yeah.
lobby on some of these things as a counterforce. All right. More criminal justice. Technical probation violations. I'll just take this one real quick, Scott. This is an easy one.
Yeah.
But it limits the amount of incarceration you can get. What would happen is, somebody misses a meeting with their probation officer, or they're late to it. These technical violations, they get dragged back into court, and they be sentenced to their full sentence for the underlying crime. It was a sort of a revolving door. This was a big issue for Delegate Scott from the criminal defense attorney down in Portsmouth. And so this makes a list of what are just considered technical violations, and limits how much active incarceration you can get for those. So you're not dragging people in on silly ticky-tack kind of violations and then stepping them back, as they say, and putting them in jail for a long period of time. Did I miss anything important on that, Scott?
Nope, you nailed it.
All right, go ahead. Why should you do bail presumption?
So bail presumptions under the Virginia Code, there's about 10 or 20 different offenses where it says if you're charged, not convicted, just charged, that it's presumed you're too dangerous to release to get a bond. And of course, the list is like over inclusive, because just a charge, just because a charge, for example, a robbery, which you're about to see here in a second, some robberies can be really bad, and some of them could be just somebody getting poked with a finger and some money got taken. So, and some robbers can be really bad, and some it might be there was some other things going on that explain what happened. And so what the statute does is it gets rid of those presumptions and just basically says that every case is going to be judged on the merits, that when somebody's booked and they're brought in, the magistrate's going to look at them and say, the officer, explain what you think happened, look at this person's record, explain to me whether you think they're dangerous, and then the magistrate will make a decision instead of having the General Assembly say, do not give this person a bond, and instead of telling every judge, don't give this person a bond, make the accused person prove why it is they should be released on bond. And I'll tell you, just to give you an example, I gave a speech on the floor about this one. I had a client who he got picked up for dealing drugs in Fairfax, and he was an opiate addict. And because there was a presumption, because they got him to sell in some woods that happened to be close to school property. He didn't know he was next to a school, but it was in a cul-de-sac on the backside of the school, and there was a presumption against bond. And so he was an opiate addict. He got in, he started going through the DTs, and before I could get him out on a bond motion, he hung himself in the Fairfax County ADC. And if there hadn't been a presumption against him, he probably would have been released as soon as they booked him and brought him in, or they would have given him a cash bond. His family could have got the cash bond paid and got him out. But because there's a presumption against bond, it took like 3, 4, 5, 6 days to get him out. And that's what happens. A lot of people lose their jobs. It's pretty rare that somebody loses their life like that, but or ends up with a serious injury like he did. He ended up, he basically is comatose now. But but this law, it's just, I don't think it works very well. And I think we ought to be judging cases on an individual basis instead of just the General Assembly deciding every case from the beginning or something, which is basically how we've functioned now for about the last 20 years. And so hopefully this bill will save some lives.
Well, I think that this presumption, I think you agree, for a while there, when everybody was sort of running on a tough on crime platform, it was sort of a check-a-box thing, particularly for Republican legislators. Like, what bill what can I bring a bill to get tough on something else? And one of the ways you would do that is you'd set a new mandatory minimum on a crime, or you'd make a crime a presumption offense, so that you'd have a presumption against bail. And so they would come every year looking for new ways to show how righteous and tough on crime they were. And we're going to have to, I know some people are frustrated, we're not doing it faster, but we're unwinding again about 20 years worth of that kind of thinking in the General Assembly. I think we're going at a pretty good pace, but obviously there's more to do. You want to talk about degrees of robbery too?
Sure. That's pretty easy. So right now under our robbery statute, a robbery is basically if you use some type of physical force to get money out of someone. It doesn't matter how much physical force or whether there was a weapon used, or whether somebody actually got hurt or whatever. There's a big range. But under the Code of Virginia, it just says if you commit robbery, which could be all kinds of things, the sentence is 5 to life. And in most other states, they have degrees. A first degree robbery is just the very basic. There was a touching and money was taken, or property was taken. And then if somebody is actually injured, that takes it up a level. And then if there's a weapon used, there was another level. And if the weapon was discharged, if there was a wounding, then it's up a level. And the maximum sentences vary with each level. And so that's basically what this bill does, which is a much more rational way to charge this offense, because the way it was used before, every case, the person was looking at 5 to life, even for something really small. And I can't tell you how many people there are in prison right now on some pretty ridiculous sentences, where nobody got hurt, no weapon got discharged. There was, somebody was like really young, really desperate. And so we need to have more sort of caps in our system all the way up to take into account some of these more minor situations.
Yeah, no, I think that's right. I know that what you find with a lot of these, and part of the reason, again, that the Commonwealth's attorneys were so adamant about having these is a lot of this was just about getting leverage, right? You find that Commonwealth's attorneys didn't want to try cases. And so you can make people plead guilty if they're facing these huge potential consequences. The same thing with eliminating the jury trial penalty that we got rid of during the special session. So
that's right.
Again, we're making strides to try and even the playing field between defendants and prosecutors, and just not trying to be soft on it, but just make sure everybody gets a fair opportunity. You're not presented with an impossible choice and pleading to things you didn't do or the state can't prove you did because you're afraid of the consequences. Let me get the slides back up. I think
next we got motor vehicle insurance,
right?
No, motor vehicle insurance.
Oh yeah, motor vehicle insurance.
Yeah, that was my bill. So we are raising the motor vehicle auto insurance minimum policy limit for the first time since I was 4 years old. I think Marcus was 5.
I can't believe there hasn't been more press about this. It's such a sexy topic. But go ahead.
Yeah, but right now the minimum policy in Virginia is $25,000. This raises it to $30,000 January 1, and then it goes up to $50,000 in 2025, which will tie us with Maine for the highest in the country, and it really ought to be higher. In Europe, the minimum policy is $1 million, and we're fighting about whether or not to go from 25 to 50. But I can tell you, since 1975, the last time this was done, emergency room bills have gone up a lot. Like the price of a car has gone up a lot, right? And the size of a claim is typically based off medical bills and property damage, right? The average car cost $4,000 in 1975. Medical inflation has been like something like 200 and some percent or something like that since then. So this will just help more people to get compensated. It'll actually save taxpayers some dollars because Medicaid actually takes some money when people get hurt who got their health care from Medicaid. But what this really does is it puts the cost of car collisions or accidents on the people who cause them and not on taxpayers. This is the second year I put this bill, and I'm happy we finally got it done so I can work on something else next year because it was way overdue, way overdue.
Well, the other big, really, I mean, talk about big things. And again, it's I know we keep saying this, but some of these things are a big deal. But we really are transforming our court system in Virginia by expanding the Court of Appeals. This is one where I think people don't realize what a big deal it is because I think people assume that it's been this way, and people don't realize that we don't really have a full-fledged Court of Appeals. And for a lot of your cases, you go to court, and if the circuit court really doesn't go your way, your appeal is to them again, ask them to reconsider, or straight to the Supreme Court if they'll take your case.
If they'll take your case.
Right. So talk to us a little bit about the expanding the jurisdiction of the Court of Appeals.
Yeah, so I put this bill in last year. Virginia is the only state in America. We're the only state where you have no right of appeal if you lose your criminal case or if you lose your civil case. I mean, this is another situation where Virginia is like way outside the mainstream, and we have been for like 2 decades now. And so this basically gives everybody a right of appeal in every case now, whether it's criminal, civil, whether it's trust in estates, whether it's real estate, whether it's divorce, whether it's, a personal injury case, a breach of contract, commercial, whatever it is, you now have a right of appeal finally. And we didn't have that in Virginia, but in order to do it, we have to have 17 judges to process. And one other thing people don't realize, the Court of Appeals right now has 11 judges. There's one judge on that court from Northern Virginia, 1 out of 11, right? There's not a single judge on the Supreme Court from Northern Virginia right now. There's not a single one who lives in Northern Virginia. Bill Mims used to live up in Northern Virginia. He moved down to Richmond about 15 years ago. There's nobody on the Supreme Court from Northern Virginia. we should have on the Court of Appeals, if we have 17 judges, we should have like 6, maybe 7 from Northern Virginia. We don't. There hasn't been a single judge from Fairfax County, which is 20% of the state, go up to the Court of Appeals since 1995. And nobody from Arlington or Alexandria since before that. Okay. So our part of Northern Virginia, our part of Virginia is completely unrepresented for the most part on these courts. And if you want to, if our part of the state wants to have its say in sort of what the law should be, when, you know, the gray areas that have to be filled in after we pass these laws, we ought to have some seats on that court, and people ought to have a right to have their case reviewed, or else, you know, circuit court judges have just a tremendous amount of power. They can just make decisions and assume it's never going to get reversed because these courts won't hear their cases. Not anymore. So I was excited we got this done.
Yeah, no, and I think gives us an opportunity to send down some judges that have some experience. I mean, we hear cases in Tyson's Corner that other judges don't have any experience, and the ones that do get appealed, you know, are some big deals. And so I think it's going to be great. And having 7, you know, at a time gives us an opportunity to address diversity, regional diversity, which we were talking about, but all kinds of diversity, so that we can get some make up for some lost time when you had a party that was electing these judges that really didn't have any real interest in keeping a court that was diverse and looked like and had experience from all over the state. So we have an opportunity to begin to address that. I'll do one more. I think we have one more courts bill, which I will take because it's an easy one. I think the hard courts bill is for Scott, and I take the easy ones like he's a real lawyer, as we like to think, goes to court all the time. But no fault divorce, this one's easy. This is the one that essentially required people to come and lie, right? So in a no fault divorce, you still have to have witnesses show up in court and testify that they have actual knowledge that the parties have been living separate and apart for the statutory required, you know, period of time. And they've got to swear it under oath, under penalty of perjury and everything. And it's something that you really have no way of really knowing. And frankly, you know, particularly during COVID, it became really apparent. I had all kinds of different situations where people would move to different parts of the house to try and meet their requirement for living apart and so forth. So basically, we said is, you know, we're not going to require anybody to go out and find folks to testify to this.
But you also have to corroborate it. And I mean, during COVID, we told everybody to stay away. So you couldn't go into somebody's house to see if they're still living together because we told everybody not to. That's like
right. It's corroborating ways. Right. Exactly. So I mean, again, you know, essentially, it's like you had to find somebody who was basically willing to say it. It was hard to find anybody who knew it. Who would you get that was willing to say it? So instead of suborning perjury all the time, we've just gotten rid of that requirement, which is just sort of recognizing reality. Let me talk a little bit about voting rights. Both Scott and I are on privileges and elections committees. I'm on the chairman of the House side. Scott's on the Senate side. So I think we both were involved in some of these things, but I'll go ahead and lead off. We passed, you know, the first in the nation, first southern state in the nation, but there are other states that have something that they call a state level voting rights act, but what we've done in Virginia is much more significant. And I think most people that are experts on election law will tell you that what Virginia has passed is the model that other states should really be adopting. And it's really the opposite of what we're seeing happen all over the rest of the South and all over the country. It prohibits any rules that limit the right to vote based on race, color, or membership in a language minority group. And that includes essentially things that have that effect, not necessarily that have that intent, but that have that effect. And one of the, for example, you've seen in other states and other places, efforts to close voting locations and limit, you know, the number of precincts in a place like Milwaukee, Wisconsin, or something down to like 5. And the 5 weren't in the neighborhoods where Democrats voted. So you can't make changes like that are going to impact folks based on race, color, membership in a language minority group. Also prohibits at-large elections that would inhibit a protected class to elect candidates. We had a separate bill, which isn't really on this chart. We had a separate bill about Virginia Beach. It's interesting. That was a fairly controversial bill, but Virginia Beach has this weird system of voting where they have wards. So people vote from a different ward or different district within the city, but everybody in the city gets to vote for it. So it'd be like folks in Mount Vernon decided they don't like the way John Faust is running Drainsville, and so they could vote in the Drainsville elections. Or if you had a situation where
that's the way we elected delegates in 1971 when my dad ran for the House of Delegates in Fairfax County. He had to run countywide for one of 10 seats, and everybody in the whole county voted for everybody. It was crazy.
Right. So at any rate, any kind of, the reason that you do those sort of weird at-large voting systems, again, is to dilute minority voting power. I mean, there's really no other good reason or explanation. You can come up with some other explanations for it, but that's what it's about. I had to argue with folks this was, we weren't preempting a federal lawsuit, but as I said, I didn't really care what happened with the federal lawsuit. I thought it was wrong. And so we could make it illegal whether it's
right after we passed it, the judge said that the system was illegal and unconstitutional.
Unconstitutional anyway. So we were right. So it's good to be right. And then the other bill that we did on voting, the other big bill, we did a lot of things, but the other really big bill that I wanted to talk about is the absentee voting bill. We did a lot of this during COVID, and a lot of what we did this session was to make that stuff permanent. So we allow so every state, Fairfax County has always had a central absentee precinct to manage the absentee ballots. We're going to require every locality to have an central absentee precinct. We're also going to require basically everything you've heard about what they're doing in Georgia and Iowa and Arizona and Colorado, or not Colorado, but these other states, Nevada, that's where it is. Everything they're doing there, we did the opposite of, right? So we're going to make sure that you have an opportunity to cure your ballots, your absentee ballots. If your absentee ballot shows up 2 weeks early and there's a technical problem with it, we know it came from you, but we know you forgot to do something. Somebody's going to call you, say, come on in and fix it, as opposed to just throwing your ballot away. We're going to have drop boxes, the way we had drop boxes during the 2020 election. We're going to repeal restrictions on first-time voters. So anybody who's even first-time voters can vote by mail and vote absentee. And we're going to start processing the absentee ballots earlier. There's two problems that kind of presented themselves with the real increase in mail-in balloting. We fixed one of them. We haven't fixed the second one yet, and I'm open to suggestions for how to fix it. But the idea that you didn't get the absentee ballots till very, very late at night, right? So CNN and John King were saying, I don't know what's going on in Virginia. It looks like maybe Trump's going to carry Virginia. And it's like, you guys just shut up and wait. Fairfax hasn't counted its absentee ballots, and so we haven't reported yet. So we're going to require that absentee ballot stuff to start being counted earlier, so that we're able to do the final tally closer to the time all the precinct returns come in. We haven't yet figured out how to sort everything by precinct so that after it's all done and said on election night, you can then take those absentee ballots and send them and figure out which precinct they came from, so that I know how well did Joe Biden do in precinct 304 versus 717 versus wherever else. We're still working on the best way to do that. So did you have anything you wanted to add on either one of those bills, Scott?
No, counting absentee ballots by precinct was a bill that I introduced in 2010. So I was glad to see that all of a sudden everybody realized the wisdom of my my foresight 12 years ago. But now that it's good we're going to be starting to count those early. I'll never forget in 2006, it was the Fairfax County absentees that put Jim Webb over George Allen. And I remember being in the Fairview Park Marriott Hotel watching those results come in, and right around 11:30 at night, Fairfax reported and the race was over. And ever since then, it's always been when are Fairfax's absentees coming in? When are they coming in? When are they coming in? Now I won't be getting these calls from my relatives across the country every presidential election now, wanting to know what's wrong with Fairfax. So especially with these huge numbers of people we have voting early now, I mean, it's really important we get started. So,
well, I think and now that we've gotten rid of we explicitly had no. You and I have been coaching folks up for years on all the different ways they could vote absentee for no real good reason if they didn't want to, because there were plenty of reasons we gave them, but getting rid of that requirement. And I think now also having everybody sort of proof of concept, once you started and tried it, you realize how convenient it is. I think a lot of people are going to continue to want to vote at home and early. A bill that has some local impact here and was very, very, probably one of what was by definition the closest vote of the session, because it was it required a tiebreaker, was the abolishing the May general elections. And so we've shifted all local elections after. So this will be the last May election for localities. Starting in May of 2022, so May of next year, everybody's going to have to run in November. So anybody whose term is about to expire, any town council members or mayors or whatever, their terms will be extended to the November after, or well, I guess till January after. They'll be up in the November election.
Yeah.
This was a really tight one on both sides, but we got the votes we needed to do it. I mean, ultimately, with all the work we did on voting rights this session, on absentee voting, with all the arguments we made about how elections are better when more people vote, and the more people you can have turn out, the better your democracy is. It was sort of hard to argue the arguments we heard from municipalities, which are, well, we like people who are really focused on municipal issues and people who really care about this stuff. And I mean, basically, these arguments boiled down to we like the right kind of voters to show up for our elections. And that's not an argument I think Democrats can get behind these days.
No, the founding fathers were down with that kind of argument. Back
Exactly.
I'd have 20 acres and be the right age and have the right chromosomes to vote. But
Well, it's interesting on right-wing social media, you hear people talk about raising the voting age to 25 or 26 because they don't like their brains aren't fully formed. These young people don't know what they're doing. So there's a movement to go back that way, but not here in Virginia. I'll briefly talk about
Fairfax, by the way.
I had a bill, and Scott, I will say, worked hard, I think, to try and help me get his caucus to a place where we can make some progress on this. I had a bill to ban the personal use. It's interesting. This has been a bill I've introduced pretty much every year, I think. Yeah, starting in 2014, we called it the Tim Hugo bill at the time because it was very political at the time, so it would die fairly promptly. But yeah, we've gone through some of the what ifs and what abouts and what can you do questions in the House. This is sort of the first time it's really gotten a serious hearing in the Senate, and so they hadn't yet really had some of those conversations, and so there was just a lot of discomfort, I think, on the among the senators about not creating traps and unintended consequences for themselves for what is essentially innocent kind of conduct with their campaign funds. I'm hoping that we can get this into this study. That's the segue into the big comprehensive study that Delegate Bulova sponsored, and I would have sponsored it, but he already put his in. So I was happy to just glom on and be a patron of his. But we're going to look at some other big issues out there. I mean, I think, in addition to personal use of campaign funds, we need to look at these unlimited expenditures by individuals for folks, and what the best way is to address that without just pushing the money into a different channel, right? And making sure we have everything properly disclosed and can hold people accountable for it. But when you have folks that can come in and essentially buy themselves a legislative seat in the primary with a couple $100,000, I think everybody agrees we need to figure out a way to address that. So you want to add anything to that?
Yeah, well, first back to the personal use bill. I don't feel like there was a lot of objection to prohibiting personal use of campaign funds. It's just the question is, how do you do it in a way where you don't get people inadvertently committing crimes or creating opportunities for complaints? And what do you do about bogus complaints? Because as soon as you create that opportunity, that in the campaign cycle, somebody's going to file some bogus complaint. They're going to see something on a report and be like, "Oh, that must be personal." I saw Surovell eat a slice of pizza at his volunteer thing, and and then the headline is complaint filed, and you can't get away.
Oh, Scott, you just knock your microphone out. You just pull it out when you're waving your arms.
Oh,
there you go.
Is that better?
Yeah, I can hear you now. The last thing you said was
Okay.
complaint filed, and
yeah. Okay. Sorry. Yeah,
my
my arm slammed down on the button here.
you animated.
Yeah. So, but in any event, there's just a lot of concern about how this would actually be implemented. And I think that's what we got to work through. And we'll probably work through that over the next 12 months as part of this study and come out with something next session. On the bigger bill, but Marcus sort of outlined it there, the big issues. I mean, the federal cycle, you have all these caps, right? You can give this much here, this much there, this much this time, this much that time. You can give a little bit to whatever. All that does is that if you are the kind of person that has $1 million to put into a race, it means you put a little bit here, a little bit there, a little bit here, a little bit there, and then you take the rest, you drop it in a 501c4 that that basically says, good Fairfax, says this, and and you can't see who wrote the check and where it's coming from and who's, or whether there's 10 rich guys or 10 corporations that are funding the thing, or it goes into a 527, or maybe the money goes to the DLCC or the RLSCC instead. From my point of view, it's like you're on top of a mountain and somebody dumps a bucket of water on the top of the mountain. It's going to get down to the river one way or the other. And the way it works right now in Virginia is you can see that water the whole way down because it's in a channel flying right into the river. But if you have a system that's too restrictive, it trickles down in a lot of different ways. Some of it goes underground, some of it goes different ways, some of it evaporates and rains down. So you never know like how it got there. And it's important that we see who is trying to influence our elections and how they're trying to influence it. And that's the balance that we have to figure out.
Yeah. All right. Housing. We'll both do some landlord tenant, some housing law, but I chair the Housing Subcommittee on General Laws, one of my many jobs in the General Assembly. And so we've done some stuff for tenants, and particularly trying to make sure people can stay in their houses coming out of the pandemic. So HB 1889 requires, there's a couple of things. One, in Virginia used to have what's called a 5-day notice to pay or quit, which is a really short period of time. It's like you got 5 days to come up with the money, or I'm going to court and I'm going to get a unlawful detainer and kick you out of your house. So this now changes that 5-day pay or quit to 14 days. And then also requires landlords that have 4 or more rental units to inform the tenant basically of a reinstatement amount, right? Like, hey, here's how much it's going to take you to get caught up. It's like the back rent plus penalties plus attorney's fees or whatever else I've done to have to try and collect the cost of collection. But I will total it all up for you and allow you, if you come to an agreement, you can pay it all off over time. You can stay in the house. And so it requires everybody to come up with a payment plan. I'm told by the professional landlords that this is just good business. I mean, typically if somebody's been affected by a COVID layoff or a short-term kind of joblessness, or they've run across some hard times, it's a tremendous number of renters in particular don't have 6 months worth of living expenses saved up. So something goes wrong, they fall behind, they get a job, they can get caught up, and they can't get caught up all at once. And so this will allow folks to spread out whatever their arrearages are over at least 6 months. And we also, there had been previously under the emergency legislation, a cap that said you can only do that once a year. We've eliminated the cap on entering into payment plans. As a practical matter, you probably won't do it more than once or twice, but there's no reason, as long as the landlord is being made whole at the end of the day, at the end of the payment plan, no reason not to let people enter into more than one. So that's what that one did. And then it's funny watching the Senate try and wrap their heads around this one. Sorry, Scott, but people didn't understand what an illegal eviction was. I think Adam did a good job finally of explaining it.
I know what it is.
You know what it is. What do you mean an illegal eviction? What about the poor landlord? I'm like, this is one case where you don't really have a poor landlord. I mean, every now, some things like, it's a matter of shifting. Somebody's is going to be out the money, right? Who do we want to protect, the tenant versus the landlord? And there's somebody innocent in some of this. Illegal evictions are basically when the landlord says, I'm changing the locks, or I'm turning off your heat, or I'm cutting off the water, or I'm going to let the gas company come by and shut off the gas, pay the gas bill. You can stay in the house because I can't evict you, but I'm going to shut all this other stuff off and make it uninhabitable. And that's against the law. You can't do it. But people do it. And then, so what this bill does is it toughens the penalties on that and gives expedited court hearings to people that feel like they've been the victim or about to be the victim of an illegal eviction.
Yeah, and I'll say, I don't do a lot of landlord tenant work, but I've done, probably, a couple dozen in 25 years of practicing law, and both sides, representing both landlords and tenants. And, the professional landlords don't do this kind of stuff. They're not that stupid, but there are some mom and pop landlords that are either just malicious jerks or clueless jerks that think they can just go change the locks or something. Or I actually had a case last year. I did a pro bono case for a Salvadoran couple last year, and they didn't speak very good English, and in any event, I actually saw somebody try to lock somebody out. The landlord moved in, started moving their stuff out. They called the police. Police didn't get. I mean, this happens, right? Doesn't happen a lot, but it happens. And when it happens, there needs to be massive consequences for a landlord to make sure it never happens again. Because we, in a country with the rule of law, if you want to get somebody out of your house, there's a process you have to follow, and then you have to get an order from a judge, and then you have to call the sheriff and get Stacey Kincaid to send her guy over to watch it happen. That's how it works in this country, right? But and it doesn't. There's some landlords like to take it into their own hands, and if we want to incentivize them not to do it, we have to have these kinds of laws. And it is a lot harder to evict somebody now than it was 2 years ago, thanks to the laws we passed in the last 2 years. It's a lot more balanced. We used to be an extraordinarily landlord-friendly state, and now we have some balance in our system finally. So that's a good thing.
Yeah, and I mean, my experience with these mom and pops even is sometimes they're not bad. They're just it's a business decision. It's like, well, what's the worst thing that can happen to me, right? If I just change the locks, maybe they'll go away. And even if they don't, you know what? What's the harm? And so that's why you got to make sure that the penalty. You really have to think more than twice about trying to get away with something like that.
Yep.
Gun violence, firearms. We aren't done with those.
We can skip guns. I don't think the Democratic Committee cares too much about this issue. Skip it. No. So, you want me to cover the first one?
Yeah, why don't you do that?
Okay, so the first one has to do with basically codifying what Governor McAuliffe and Governor Northam have done for firearms in state buildings. So we're not talking about the courthouse. We're not talking about the recreation center. We're not talking about schools. County buildings we covered last session. That was my bill, Senate Bill 35. I carried with Delegate Cia Price. That gave our local government authority for firearms in their buildings. This has to do with state buildings. So this is like the General Assembly building, the state capitol. It's like, for example, Department of Environmental Quality has some premises over in Prince William County, probation and parole offices, community colleges, things like that, right? Universities. So basically what this does is it codifies the executive order, which bans firearms from state-owned buildings, not only buildings owned, but buildings that are also leased by the Commonwealth. It does, however, say that the state has to lease the entire building and not just like one suite or a floor in it. So if there's a state office that's in a suite in a big building, that doesn't count. But if the state has the whole building, then you can't have a firearm. And this is a real, this was, the first 10 years that I served in the legislature, or I guess the first 8 years before Terry McAuliffe was elected, people would regularly, come onto the state, the Capitol grounds with their firearm. And actually, firearms weren't even banned from the General Assembly building until 2 years ago. And, I had people in my offices with AR-15s. I had people in my offices with all kinds of guns walking around within our building in our committee meetings. I mean, that was totally okay. And
Senator Marsden put up a sign just to try and preserve his little corner of the Senate office building. I think Senate Clerk Schar made him take it down.
Yeah.
Right.
Yeah, that's right. So this says no mas. So it's a good thing. It'll make things safer. So, they can't have that that rally they had. People will still be able to walk around the streets of Richmond, I guess, but not on the streets around the Capitol Square, like 9th Street and Bank Street, or on the grounds there. So that was what that bill did. And then the next one.
We worked on the exceptions. There's always, you have in a container in your car and you happen to be driving down 9th Street. You're not going to get, in trouble.
Right.
For that,
right.
You can't be sitting in the back of a truck, waving it around, honking your horn and waving your Confederate flag, which we've seen down in Richmond. Polling places, this one seems like common sense, but this Delegate Levine's bill, but we prohibited not just brandishing, but bringing your firearm to polling places, so that you can't have folks standing, self-appointed voter integrity militia, standing outside with their guns, trying to intimidate people and or trying to bully elections officials. Which, frankly, the registrars, even from ones from far southwest, some of the rural areas, we're actually very glad to see us pass this bill. They don't want folks coming in with a big pistol on their hip.
I actually had mixed feelings about this one because, at least in Fairfax County, guns are already mostly banned from polling places because they're mostly schools. And I don't really feel like the concealed carry is the issue. It's really the open carry. And I feel like what ought to be illegal is open carrying a gun within so many yards of a polling place. Because the way this is written, you can still stand with a gun across the street as long as you're not on the property. And I think it's if you're within sight of a polling place, you shouldn't be marching around with an AR-15. And I think that's really what it ought to be aimed at. And maybe we'll come back and look at that a little more. But the way it's written right now, we have a few polling places in Fairfax that are like at churches or some other non-governmental buildings, but it's an important first step, I think. But I think we need to do more there.
Yeah. This was HB 1992. Scott, you and I have been trying to help Delegate Murphy get a version of this through, I think, again, for many years. I introduced a bill. Actually, the very first bill that I ever introduced was HB 48 in 2014, which Jim Scott had been carrying for years before I got there. That's the reason it was my bill number one. To try and align Virginia law with what the old federal rule had been, which is that if you've been convicted of a misdemeanor domestic violence, there's a lot of domestic violence that is charges misdemeanor for a variety of reasons. One is because you want to keep the family intact, and there are a variety of reasons to not make a lot of this domestic violence a felony, because you do want to keep people together and give people second chances and so forth. But because of the nature of the crime of domestic violence, it does often escalate. And so trying to keep firearms from people that have been guilty of misdemeanors involving domestic violence has been a challenge for years. I think this year we got a bill where we limited the definition of domestic violence and assault and battery on a family member and household member. And we also have an end date on it. It's not a forever prohibition. Did we settle on 5 years, I think, Scott? I know we went back and forth between 5 years.
I think it was 3. I think it was 3. I think the governor proposed 5 and we rejected that.
So it's back to 3, right?
Yeah, but the other thing, the reason this bill has had issues through the years is that, anybody who's convicted of domestic violence is barred by federal law of possessing a gun. And so a lot of folks on my side said, why do we need to do this? Why do we need a state law when it's already against federal law? And the answer to that is so that the crime can be prosecuted, because the Department of Justice never brings a charge against somebody who convicted of domestic violence for carrying a weapon. And so in order to have actually an enforceable system, you need to have some kind of system at the state level. And so that's why we had to adopt a parallel system. And we were finally able to narrow it down enough to get enough people comfortable with it to get something through. So
all right, we're about halfway through, and we're only, I think we're doing pretty good. But
yeah,
let me just quickly say I did have a bill that would have banned ghost guns, and it failed. It got very close. We got to a conference committee because, again, some folks in the Senate were worried that it's interesting. I'll just strategically, we started out with a very broad bill that banned anything that didn't have a serial number on it. And we kept, whittling it down and trying to narrow it and focus it more on just the issue of ghost guns and the manufacture and creation of these 80% lowers and things like that. But sometimes once a bill has we saw this, I think, last year with the assault weapons ban. Sometimes the initial impression that people have of the bill is hard to shake. And politically, it makes it hard for people to support it, even if they might want to support the narrowed down version. This is a big problem, though, and we do have to come back and address it. I went to a gun show in Fredericksburg a couple weeks ago. I walked in with no ID, paid cash, and bought a what's called an 80% kit, which means I got a plastic receiver. It's the lower part of a handgun. I needed to drill 2 holes for pins to hold it all together and file down some tabs. They're plastic, so it's pretty easy to file them down. It wasn't like any heavy equipment. And I made myself essentially a Glock 19 out of untraceable parts with no serial number at all. And I'm not that handy, believe me. Ask my wife. I can't fix anything around the house. So you don't need any particular skills to do that. So it's something we need to get back to. I know Joe Biden's working on a federal solution, but something we'll revisit, I'm sure, in Virginia. All right, let's go to the next one.
You're going to invite me next time you go to do that.
All right, we'll have fun. I'll invite you to the range. I think Stacy's in case that she'll let me come to a range and fire it safely there and make sure it actually fires. So I bragged about how good it is. I haven't shot it yet. We'll see. Who wants to talk booze? Why don't you talk about booze, Scott?
Okay. Yeah.
Quality of life. I like the title.
As the
RLA's put this together.
Third ranking member of the Rehabilitation and Social Services Committee that hears these bills. Don't ask me why ABC bills are heard in the Rehabilitation and Social Services Committee, but that's where they are in the Senate. The The first one that has to do with these outdoor refreshment areas, which we authorized. I think it was last session. I don't think it was in the special session. I think it might have been the session before that. It might have been the special. I can't remember, but it basically provided some relief to some of these restaurants where people don't want to go inside, but maybe they're willing to drink, have drinks outside. So for example, if you've ever been to the city of Manassas, they've got this little downtown and there's restaurants all over it. They basically shut down the streets at a couple of different ends, and people can like walk out in the street with cocktails like Bourbon Street or something, but they only allow it, I forget, it was like 3 or 4 or 5 times a year or something like that. This enhances the number of times in a year they can do it at a particular location. And a lot of the restaurants really thought it was a good idea and they wanted to have it. And then the other bill, another thing we did during pandemic time to help keep our restaurants going, was we allowed people to get a cocktail to go. And some people think, well, who would want to just get like one cocktail to go? It's not really what happens, right? There's some restaurants now that are like making margaritas to go, and you buy them by the gallon. You can take a gallon of margaritas or a gallon of sangria or something. You can take it out with you from the restaurant, so you can go down and get it and bring it home and to your party or something like that, and get your margarita from Chi-Chi's or whatever. I don't even know if Chi-Chi's exists anymore, but anyway, you can go get. I'm not a big margarita fan, but anyway, that we extended that beyond pandemic times to I think we extended for another year. I think it still has a time limit on it. I don't think it goes on forever.
It still has a sunset, I think. So we're gonna see how it goes.
Right. What's next?
Constitutional amendments. I think again, Scott, you and I have both introduced. I remember presenting this together on a couple of occasions in front of civil sub for Greg Habib back in the day. We took turns, just like this actually, but we were presenting our bill. But we actually, last year, after all the fanfare about it, last year, very quietly, Nancy Guy, a freshman House of Delegates member, put in a bill to repeal the statutory ban on same-sex marriage. I actually had the repeal built into a much bigger bill that I did on getting rid of gender-specific references to husband and wife throughout the code, including repealing the statutory ban. But we can't change the Constitution without a new constitutional amendment. So Mark Sickles and Adam Eben were the chief patrons of the constitutional amendments in the House and Senate that will repeal the Marshall-Newman Amendment and replace it with a fundamental right to marry. So it's not just a straight repeal. It's going to go a little further, and it's got some nice sort of poetic language about love is love, and everybody should be able to marry who they want to. And
yeah, I'm a little worried about that.
So Scott's a little worried that that's going to lead to some arguments that will cause it some difficulty at the ballot box. But that's where we are.
Now, not only that, the time we passed this, the GOP was down 1 vote in my chamber, so we were able to pass a lot of things 20-19 or 21-19. But now that they've got their new member elected and everything's 2020, all we really needed to do is take the ban out of the Constitution. But putting the affirmative right to marry into the Constitution is a different policy decision, and I'm a little worried about that. But we'll see. We had the votes to get it done this session, and when it becomes the final vote, that puts a lot of pressure on people to get on board. So hopefully we can get that done next session. But yeah, you're right. It creates some other opportunities for argument at the ballot box, and some of these courts have really weaponized some constitutional provisions in weird ways that you need to think about carefully. So you might cover the next one.
Yeah, go ahead.
Yeah, well, Delegate Simon and I both helped get this one to home plate. It was Delegate Majority Leader Herring and Senator Caucus Chairman Locke's constitutional amendment. And this one takes the Jim Crow language out of the Constitution, which basically right now, if you're convicted of a felony, you're automatically disenfranchised. The only way you get your right back is when the governor restores it. And luckily, we've had 2 Democratic governors, which has created a more or less automatic restoration process as a practical matter. But we're one of only, I think, 2 or 3 states in the country where you have to go to the governor to get your rights restored. And, and the whole point of that was intentional. If you go back and look at the minutes of the 1902 Constitution, they basically said the point of this is to eliminate the darky influence from the state government or something like that post Reconstruction. And so this coupled with the poll tax and the literacy test were sort of the big 3 ways they disenfranchise people. So this gets Jim Crow out of the Constitution, but we also replaced it with an affirmative right to vote, so that once you're out of prison, it does not apply to people who are currently incarcerated, but as soon as you're out of prison, it says you have a fundamental right to vote. And what that means is not only will we have the Voting Rights Act that Marcus talked about a little while ago that we passed, where we have this statutory lawsuit that can be brought if somebody's limiting your voting rights, but it has a constitutional provision saying you have a right to vote, just like the right of freedom of speech, the right to freedom of religion, the right to freedom of the press. You have a right to vote. And so the courts could also use that constitutional right as a basis to invalidate any kind of restriction on people's right to vote, assuming this is passed again next session and approved by the voters. I think it's a big deal.
Yeah, I mean, I think it's a big deal. This is, like a lot of things, it doesn't go as far as a lot of people would have liked. And that's, again, same sort of concerns that Scott talked about with the marriage, putting an affirmative right to marry. The idea of, well, one, I mean, I think Scott and I personally would both have been fine with a fundamental right to vote that never went away, even when you're in prison. But getting the votes for that, not just in the General Assembly, but at the ballot box is difficult. The optics of that are just challenging. And so I don't think we wanted to risk the whole thing. We started out, like Scott said, with two different bills. On the House side, it was literally just getting rid of the Jim Crow language and making restoration of rights automatic for felons. I didn't get rid of it. It made restoration of rights automatic. So you didn't have to apply. Once your jail sentence was finished, you could get your right back. And on Senator Locke's side, she had just a right to vote that you never lost. So I think we came to the best balance between those two things that we could, and that we get something passed. So I was pleased with the way that one's turning out. And I think it has the unintended benefit, not consequence, but benefit also of being a good bulwark against, again, if there's a, God forbid, a change in the majority from a sort of legislative backsliding on voting rights.
Yep. So we have a couple human rights bills here. We can go through these really quick, but Delegate Sickles, his adds discrimination on the basis of disability to a lot of the bills that we passed last session, which give employees a lot of state level rights against non-discrimination. We've always had a lot of federal rights, but not anything at the state level that allows you to go into state court. So that's what House Bill 1848 does. 64 extends protections to domestic workers. There's a lot of exceptions in the codes for domestic workers. A lot of people feel that dates back to basically, post-slavery days, like minimum wage exceptions, things like that. So we did a lot of work in the last two sessions to bring domestic workers into line with other types of employees. And then Delegate Lopez has this LGBTQ advisory board, which we have a lot of boards in Virginia. We have an Irish potato board. We have a caving board. We have what other kinds of great boards do we have, Marcus?
It's funny because I was
corn board.
Speaker Fillercorn had to fill all these board positions when we took over. So we were looking at that list together. One of the things about you take over the majority, and all of a sudden you get all these boards to fill. But we didn't have anything for the LGBTQ plus community before now. So.
Yeah, overdue.
All right, let's see. Did I skip one? No, I didn't. All right. Education. Delegate Lopez, what we're talking about, our buddy Alfonso. We passed a version of the state level version of the DREAM Act, provides the students who meet criteria to be deemed eligible for in-state tuition, regardless of citizen or immigration status. And they also qualify for state administered financial assistance programs and financial aid and so forth. So it's another one that's been a bill that was a messaging bill for a long time. We put it in knowing it wasn't going to pass because it was the right thing to do. Glad to see that one pass this year. Do you want to talk about G3, Scott?
Yeah, this is the governor's bill to try to create free community college for low-income students in careers that are very much in demand. It's not free community college for everybody, so it's kind of like, Bernie Light, but there are a lot of careers that our community colleges train for that are really a lot of people don't know about, and this will provide people with certain deserving people with a free education towards a real chance to get a job almost as soon as they get out of community college. So it was a signature program by Governor Northam, and it was carried by the Speaker and the Majority Leader, which just tells you how important it was to the governor. So,
Yeah. Yeah, whenever you see Fillercourt and Sasslaw as the patrons, that's a signal you need to get on board and vote for that.
and this next one, I don't think we passed. I'm surprised that's on there. I thought I'm trying to look that up right now, and I'm not seeing it on the list. Did we pass that?
This is not the big time SOL reform. This was a smaller one, I think. Let me take a look real quick. Why don't you talk about school reopening while I look it up?
Yeah, so the school reopening bill, that one was pretty controversial. It started off as a very simplistic bill, which basically just said schools are to reopen. And that's the bill that came out of the Senate. And it had no emergency clause, so it wasn't going to be effective until July 1. But it got over to the House, and the House really cleaned it up for us and got it into proper form. But going into session, we were just getting a lot of complaints from a lot of families about the fact that Fairfax County had not gone in person yet. And most of the rest of the state was doing in-person classes. It was all the Northern Virginia schools that pretty much were some of the only ones in the state that had not yet. And I got some data back from some of my schools in the Route 1 corridor showing that the number of kids that needed remedial reading help had like doubled and tripled over what the numbers normally were. It was very clear that the online virtual learning was not working for a lot of kids, especially our ESOL kids. And so I felt like we needed to do something to make sure that the ball got rolling, to make sure kids were back in school in person by July 1. And that was the bill that I was willing to support. But we cleaned it up in the House, gave it a lot more nuance and a lot more flexibility and stuff. But getting kids back in school was probably like one of the top issues that voters were asking us to deal with. I felt like going into session, and I'm glad we were able to get something done on that. And the bill that came out of the legislative process was a much stronger bill than the one that got introduced. So,
yeah. And I got to tell you, I think Scott, we have one more left in high school.
I got one in 8th grade and one in 10th grade.
Yeah, I mean, so you've seen probably what I have. I don't think anybody argues that these kids are needing to get back to school. My son, both my daughter, I have a senior and a freshman, and I can't tell you how much it meant to them to get back into school, even for 2 days a week. It was just huge effect on their mood, their personalities, their morale. Everybody gets it, but we got to be able to do it in a way that's safe. And you got to also leave some local flexibility. You talk to folks in City of Richmond schools, they're like, we don't have, windows that open. We have interior rooms with no windows at all. How are we supposed to get the ventilation in the space? You guys can't be telling us to do it before we're ready. So we did have to leave it a little more nuanced, like you said, and I'm glad to see it. So this bill, just the raw, I think it's mistranslated from my notes. It should be HB 2027 is the one that passed. 2094 did fail. That was Israel Quinn's bill, which would have just taken us back down to the minimum standards. All this one does, I always like to put in an SOL. Anything that weakens the SOLs, because my son loves it. That's the only reason he shows up.
I get standing ovations from the kindergartners don't know anything about it, but the 6th graders and the 5th and the 4th graders do.
Exactly. So the only reason he goes out and canvasses for me is because I tell him I'm going to try and get rid of the SOLs. So what this one did is it just required the Board of Education to establish, in lieu of a one-time end-of-year assessment for some of the third through 8th graders, a different kind of an SOL that measured growth as opposed to a final outcome. So did you improve from the beginning of the 3rd grade to the 8th grade? Have you shown progress as opposed to just a flat out SOL? So probably not that big a deal. Probably didn't need to be in the program, except that I had to be able to tell my kid I'm working on getting rid of some SOLs.
We passed the bill in the Senate to get rid of all take them all the way down to the minimum number. I think that's what my staff probably wrote that up, but that came out of the Senate, but didn't make it through your side, I guess.
Gotcha. On the environment, we've done a lot on electric vehicles, but styrofoam ban, right? This is one that's, again, you wouldn't have thought about having Virginia lead on or be a leader in 2, 3, 4 years ago. But Betsy Carr's bill in the House prohibits restaurants and other vendors. It says restaurants. It's a kind of delayed enactment for everybody, I think. And then it gets even further out for the smaller restaurant.
Yeah,
the big chain, it's almost immediately you got to start using cardboard. I think most of them use cardboard anyway. And it's got a phase in for like 1-off and 2-off stores to get rid of the the styrofoam containers.
Yeah, the electric vehicle bill is huge. I mean, this bill is just, but basically this authorized our air board to adopt or to bring us in Virginia into into line with California air standards. And I think there's about 12 states, maybe 15 states that are doing this, mainly states in New England, but they're all around us going north. But this will cause our Virginia auto dealers to bring more electric cars in Virginia, which will bring down prices, make them more available to really jumpstart the electric vehicle program in Virginia. And the auto dealers supported it. They want to be on the right side of history.
Watch the auto dealers. It's amazing, actually. People. I'm not apologizing for lobbyists in the industry, but the industry and what the industry lobbies for sometimes is a reflection of who's in charge in the legislature, and they're able to shift their priorities. And so I think since Democrats have taken over, the auto dealers have gotten on board with some of what we're trying to do and trying to figure out a way to make it work. And electric vehicles seems to be one of those. I know for years they fought Tesla coming into the market for a variety of reasons. Not so much about electrification, just their business model. But I think they've decided rather than trying to fight them, they're going to beat them at their own game. And so they've been big supporters. And we only have one of the bills here, the Reed bill, but Lamont Bagby had part of this. I think there were three big bills that made it up. But I know on the House side it was Reed and Bagby that had.
Oh yeah, Bagby's bill isn't even on here, and that bill is the big one. Reed's bill is the rebate. Yeah.
Yeah, this is just the rebate, but Bagby's bill is the bigger one. There's another one that had to do with the electric infrastructure stuff. I think,
yeah.
I remember that one.
Yeah, 1174 was kind of controversial. It sort of defined this new manufacturing process for plastics, and some people think that it's really not really recycling; it's just manufacturing. And but we passed it, and it creates a new recycling process for plastic. Right now China doesn't take plastic anymore, and so people are trying to come up with new ways to process plastic, and this is one of them. And there was a lot of consternation on it, but ended up getting the votes to go through. And then the gold mining study, I guess they're looking at doing some gold mining in where is it? Is it Orange County or Fauquier? I forget. There's some gold mining that's under discussion somewhere, and this creates a gold mining moratorium so that we won't have any gold mining in Virginia until DEQ takes a look at it and makes sure it's safe to do.
And apparently, we also forgot to do a bill about our $800 million wastewater pollution something or other. Chesapeake bill that Alfonso Lopez negotiated. So,
is that what my phone's making noise?
That's why your phone's making noise. All right. Let me talk about FOIA. One of my new jobs is being on the FOIA Council on the House side. We've done so. Interestingly enough, as much as I know you guys all love meeting by Zoom, and in a lot of ways, electronic meetings are great because they allow for more casual participation. You don't have to plan a trip to the government center to go participate. For open government folks and the Press Association really hate them. Not surprisingly, just it may not be intuitive, but they like to be able to be there, and they like to see everybody who's participating in the meeting and be able to see them talking to each other, what they're saying, and have an opportunity to talk to everybody. And so our open meetings law has been fairly restrictive about allowing remote participation for meetings of boards and local governments and local governing bodies and local boards and so forth. So what HB 1931 does is it allows members of a public body to participate electronically. Again, participate in the meetings electronically. But it applies to anybody who's got family and medical leave type of issues. But I will say, I think it's fair to say that it's been championed by women elected officials in particular, who made us pay more attention to those sorts of issues. So this does allow them to miss more meetings or participate in a higher percentage of meetings electronically when they have personal issues that prevent them from being able to be there in person. I also worked on this criminal investigative files. Chris Hurst brought this bill during the special session as part of our police reform issue. But this has a lot to do, folks, the Innocence Project were really involved in this, as well as people that deal with cold cases. But criminal investigative files, once the police are sort of done with them, they don't allow access under FOIA. They're exempt. They had been exempted. And so folks like that want to investigate innocence claims, or folks that want to try and solve cold cases where the police have just sort of stopped working the case, but victims and their families want to continue to find out things about it. We've had a very paternalistic approach to these police files, or we didn't want people looking back over our shoulders on some of these things. This is a tough bill. It was really tough to get right because you don't want, relatives of a criminal to go find out what witnesses testified against them or what they said, or get videos of witness testimony. On the other hand, if you're pursuing an innocence claim, you do want to be able to get some of that access to some of that data. So it was sort of hard to balance that out. There are certain exceptions. And basically, if there's any other reason to keep the information secret, we sort of let that, if there's a statute specifically protecting someone from disclosure of their information, we allow that statute to trump the release, but we do open up the release a lot more. That's probably sort of convoluted.
And I've actually had people reach out to me because there's cases where the police ruled it a suicide and the family didn't believe it, and they wanted to hire an independent officer to confirm whether it was really a suicide or whether it was an accidental death versus a suicide. Somebody might have died in a situation where the family might have thought it was suicide. They didn't. I mean, there's sometimes that people want to look at these things to make sure that the police got it right.
Yep. So we've got a bill that does that, and again, it was not easy. But I also credit, by the way, Carissa Tafty, our new Commonwealth Attorney in Arlington. She really did help navigate this through the Senate, because there are some sensitive issues here, and she was really, with a prosecutor's perspective, was able, and having been a former innocence attorney, able to help us strike the right balance in some of those places. What else do we got? Let's see. Healthcare. I think this is probably not a strong suit for either one of us, Scott, but I'll let you start.
Yeah, I've been learning a lot about healthcare now that I'm on the Commerce and Labor Committee. We actually do a lot of insurance issues, so I've been learning a lot. But so Bagby passed a bill that sort of broadened the class of people that can give the COVID-19 vaccine. I think it was also Siobhan Donovan on our side. We need a lot more people to put shots in arms. That's what this one does. 537 declares racism as a public health crisis. Lasharies beat the CDC director to the punch on that. And if you saw, but the federal government just declared the exact same thing last week. It's House Bill 2332. This has to do with lowering the cost of healthcare insurance policies on the Virginia health insurance marketplace. And by creating a reinsurance program, we can get some of our highest risk, hardest to insure people a lower cost. And the big fight here was how to subsidize it. We ended up subsidizing it using taxpayer dollars. There was originally an idea that we would get private insurance payers to underwrite it, and that would concentrate that cost just on the people who get private health insurance, people that are in private employment. And we felt it was a cost that ought to be socialized across the entire state and not only on people that are on private pay health insurance. And so that's what that one did. It'll bring down the cost of health insurance for people who really need it. And then the last one makes clear that for policies that are covered on the healthcare exchange, they're allowed to provide coverage for abortion. And just so we're clear, this does not put any government money towards abortion. These premiums are all paid by the people who buy these policies, not by the government. So there's no taxpayer dollars that go to fund this, but it was important that if we're going to provide coverage, we provide the same robust type of coverage that we give to everybody. We don't have any second-class policies.
All right. Technology. We are prohibiting law enforcement agencies and campus police from using facial recognition technology. We've learned that a bunch of police departments around the Commonwealth, sort of in the absence of any regulation, are going and just buying this facial recognition technology to do surveillance and try and do facial match and things like that without any kind of vetting or standards or whatnot. So I think our default right now is that we're just banning it. I think maybe someday we'll establish some baseline standards.
Yeah, that guy Peter Thiel, the guy, that PayPal dude who spends a lot of money on conservative causes. He started a company that scraped like 5 billion images from Google and then is indexed against certain people. So you can like send him a picture and they'll try and match it. And it's wrong as much as it's right, especially when it comes to minorities. It's just a crappy way to ID people.
And then the Consumer Data Privacy Act is a state level effort to try and, again, provide a framework and begin to regulate how all these big data companies, what they can do with your consumer data and how they can share it. And I still get freaked out. What was the one I had the other day?
Google.
I was talking about something. My phone wasn't on. My Siri was probably listening for "Hey Siri," but hadn't said it. And I was talking about something. The next time I opened Facebook, the very first ad was exactly what I had just been talking about. So when anything I browse for or anything. So who knows what they're listening and selling to advertising.
I did not like this bill. I gave a speech against it on the floor. It went through first unanimously, and then after I gave a speech, it got 15 votes. And I think Senator Peterson said after I spoke, "This is the one bill that everybody's going to say they voted against 2 years from now, even though they all voted for it." This bill is very dangerous. It was written by the industry. My problem is it gives all these rules and restrictions about data about you. Okay, and this is all information about you. It's where you shop, where you eat, where you drive, what you buy. Okay. And if somebody abuses it, the only person that can bring a lawsuit about it is the Attorney General. You cannot even sue somebody about what they're doing with information about yourself. And this says you can ask them for a report where they have to give you all the information they're keeping on you. But if they don't give you the report, the only person that can sue them is the Attorney General. It's crazy. It's the only time that anybody can damage your property, but you have to ask somebody else to sue for it. You have no right to sue over your own stuff. I don't like it.
Yeah, I get it. Fairfax County. This is the Fairfax County Democratic Committee. And so Scott, who lives in Fairfax, has got some good Fairfax County bills that he wants to talk about.
Yeah, so River Farm is a 28-acre parcel over on the river. I got married there, but a lot of community organizations in Fairfax has events there. It's a beautiful property. It overlooks a bluff on the Potomac. American Horticultural Society is trying to sell it to the highest bidder, which is crazy because it was basically given to them by a donation. And anyway, we gave Fairfax County some additional authority under the historic zoning overlay ordinance to be able to put more restrictions on the property so that hopefully the property will not be developable into multiple mansions on the river. 1385 is another bill that I put in, which expands Fairfax County's ability to charge up to $1 a month on residential electric meters to pay for underground utilities all over the county in commercial areas. So I know in the Route 1 corridor, we've been looking for this. I know in downtown McLean, they've been looking for this to get their utilities underground to sort of beautify how things look and create more reliability. We're looking to do it probably in Bailey's, Seven Corners, Merrifield, Springfield. So, and then the last one is our 5% teacher pay raise. We authorized a 5% teacher pay raise. The state put up its share of the money for this, but I think Fairfax County is probably not going to get it done. They're, I think, talking about like a 2% raise, but we gave them enough money to do a 5% raise, but my guess is it's not going to happen. That's some of the Fairfax County stuff.
Call your supervisor. Questions? We're at that point. So somebody's keeping an eye on, I know there's a little bit of a delay.
Qualified immunity.
Qualified immunity.
I've been answering reporter questions on qualified immunity all day today. So Karen Kennard asks, can you talk about criminal justice reforms you did not pass, like repealing qualified immunity for police in Virginia, or passed on decertification, and how they might have impacted a case like Sergeant Major Lieutenant Michael Grinston being pulled over and pepper sprayed? So first of all, we did pass decertification during the special session. We massively enhanced the ability to decertify police officers and also to make it so that records can have to be shared when somebody applies for new jobs. People can't just hide. The way it used to work is if one of these guys did something like this, they could resign their position, keep their law enforcement certification, apply for a new job, and the new employer couldn't ask the old employer what happened. We straightened all that out in our special session last year. So now that doesn't happen anymore. And that's going to root out a lot of bad apples. It's going to be very hard for this guy that just got fired to get another job.
Yeah, he needs to be, he should be decertified. He meets the criteria for decertification.
Yeah.
So.
Yeah. And then the second thing is with qualified immunity, first of all the new restrictions on force that we adopted in the special session create bright lines that make it very difficult, if at all, to be able to assert qualified immunity. Okay, so we passed laws as you can't use a chokehold, you can't shoot a moving motor vehicle. We also passed an excessive force statute, a duty to intervene. With all those things on the books, you cannot assert qualified immunity for those things because those are clear rules, and that's qualified immunity doesn't apply if there's a clear rule. Number one. Number two, we also passed an excessive force statute, which had it, unfortunately, we actually had passed the law when this happened, but it wasn't effective until after it happened. So it wasn't effective until March 1. So the officer who you saw who's just sitting there while the other guy pepper sprayed, if this had happened after March 1, he would have exposure for failing to intervene. Because if you read the excessive force statute we passed, there was nothing that justified the deployment of that pepper spray. The lieutenant sitting in his car was doing nothing to threaten the officers. He was not fleeing. He was not a physical threat. He was not resisting arrest. There wasn't a reason to deploy that type of physical force in him. It would probably be deemed to be excessive force under the statute. And if the other officer did nothing, just sat there and watched, he could have exposure under a duty to intervene statute that we passed. In terms of qualified immunity, the House had a proposal during the special session, which got over to the Senate. It was extraordinarily broad, and we thought it had a lot of unintended consequences to it. We came back with our own version that I carried this session, and Delegate Bourne put it in his own bill in the House. His bill didn't make it out of the House this time, and my bill didn't make it out of the Senate. Both of our bills would have created liability for the officers in this situation, I think. Although I think the officers already have liability anyway. I don't think this is even a qualified immunity situation, but what happened really underscores the need to do something about qualified immunity from my perspective. So I think we're going to continue that discussion, and I'm hopeful that we'll get something done next session. I know Senator Peterson committed to have hearings over the summer about qualified immunity, so we can try and get a bill ready for session. So we're probably going to have hearings, at least in the Senate Judiciary Committee, sometime July or August is my guess, to talk about this.
Yeah, I mean, on the House side, Delegate Bourne, I supported it during the special session. I would have the broad form. I would have liked to get his bill out. Made the decision that we didn't see the prospects for it being very good in the Senate, so it just didn't make the cut to get carried over into when we switched from our regular session to our special session. We're trying to focus on marijuana, the death penalty, and a bunch of other stuff that we knew had a good chance of passing. So it was referred again to be studied. Hopefully, again, we'll hold Senator Peterson to it and have these hearings over the summer and get that done. So,
yep. So I think that's it. Matt Bell says, I have a better background than you. And he thanks Brian Graham. Oh, wait, Tura Arsala asks us about a youth task force committee. When are we going to start a youth task force or committee? Tura, I think you asked me the exact same question on the Mason Neck Forum last week. And I told you then, I think that's an interesting idea. There's no question we need to get more young people involved in policy. And it always strikes me that out of the 220,000 people I represent, 80,000 are children who don't have a vote. So getting more young people's voices in the system is an interesting idea, or getting some more young people represented on our boards might be an interesting idea. So I'm gonna give that some thought. But I think that's about it on the questions, Marcus.
Yeah, I think having either a youth board or having some youth slots on some of the existing boards that we have here. The City of Falls Church does this thing where they have, I think for almost all of their city boards and commissions, they have a youth representative. So I know the school board has like a student representative, but they put some on all of their boards. So you can get that young person's perspective. So it'll be another way of tackling that issue that I think is working well there. Any other questions that we're missing? If not,
no, that's it. No, that's it.
All right.
Well, I want to thank FCDC for putting this together. As always, Jack Corrali, our whatever you are, Facebook operator, executive director, and Brian Graham, the Uber chair, who FCDC chairs get stars in heaven for doing what they do. But we appreciate you all taking the time to let us update everybody in the committee on what happened. Marcus, you want to wrap it up?
Thank you. Thanks especially to my constituent, Jack Corrali, the executive director who put the Zoom together and makes us look good. Our
staff who put the PowerPoint together. We got to thank them.
Put the PowerPoint together. And let me just say very quickly, I have a Republican opponent this election cycle. She's did a forum with the Fairfax County Republican Committee and accused me of not being a really robust member of the community, even though I've been here since 1972. But Anyway, I may be hitting you guys up, so answer my phone when I call. I need it. I need your help. I need to hold the house. So, thank you guys.
All right. Thank you.